when the tax reasons outweigh the commercial reasons, or is it at a point of time when there's no commercial reason at all? On this also, last word I believe has been spoken. Honorable Justice Kapadia in his landmark judgment in Vodafone's case did say that as long as there is some commercial reason, you cannot disregard the structure. Now, taking this call that whether there is some commercial reason or not is a very difficult call. When we look at the complex commercial structure, a transaction structure, we look at the complexity of the structure and the flow of things. But we also need to take into account the complexity of business situations. For example, when IPRs are parked in a particular jurisdiction, it is not only tax driven, there could be other considerations. So this call which is to be taken is as to whether there is a commercial purpose, and you don't have to take this call as per the standards which were set 50, 60 years ago. Business situations are dynamic, things are changing. The business realities today are much different than the business realities 50 years ago. So if you have that ability to take that call and you have to take that with businessmen in mind, I think that is where, if you call it a moral issue, then judges perhaps have to take the call as to what is moral and what is immoral. But that's quite limited. It's not exactly the issue of morality. And as Mr. Datta very rightly said, morality and legality, it should not be seen in contradistinction with each other. There could be something which is quite moral, immoral, and it is legal. So, but then the broader question is that was it not unrealistic and was it not unreasonable on the part of the corporations to use these tax-driven structures which put corporates over for an unfair advantage over all other taxpayers, and vis-a-vis the ordinary honest tax-paying public also? It will be ignored forever. We live in a society where taxpayers are very well aware, their awareness levels are high, and the pressures on the governments also is proportionately going up. So how long will this be taken? When you come across as an ordinary taxpayer, seeing these corporations getting into structures which appear to them, because as I said, they don't have benefit. An ordinary person doesn't have benefit of understanding the complexity of the culture of a transaction structure vis-a-vis the complexity of business requirements. When it appears to him that all these structures are completely tax-driven. Which all the four examples which Mukesh has taken, these are the examples where many people believe, rightly or wrongly, that transactions were done with an eye on the tax benefits flowing from this structuring rather than commercial reasons. The Starbucks, for example, I'll not go into specifics beyond giving just one small point. When you talk of the Starbucks, what you need to realize is this: you make a payment to a Dutch company without withholding taxes, and the Dutch company pays tax which is said to be low, but again, after all these public hearings, nobody knows what was the tax rate. It is covered by confidentiality, and then 99.8% of this is remitted to a Bermuda company. So it's not a transparent transaction. It has certain degree of opacity, and therefore there's a public outrage against these kind of transactions. Now these are the transactions where form and substance has a role to play, and these are the transactions where difficult calls about the business purposes to be taken. I'll just conclude this segment by saying that as I talk about business purpose, I'm alive to the fact that business situations are very complex today. They can't be simply saying, why do you park your IPRs in Ireland? There could be much more than tax. It is not the 2% negotiated tax, as Mukesh pointed out, but it could be a little more than protection of the IPRs itself. But then the question is that what should the judicial officers do when these complex transactions come up, and how this is taken by them? Now this is where there is some problem area, and problem area is sometimes you see the lack of ability, and when I say lack of ability, I'm talking in a different sense. I'm saying lack of that combination of legal skills and the ability to visualize business. So sometimes it is that lack of vision about the understanding of the business situations, or maybe it could be simply a confidence, or some people call it sheer populism. But that's where the issues of ability or inability of judicial officers on these complex situations come up. And I would say that one has to stay away from both the extremes and take a very surgical approach to this kind of decision making, but that's something which is easier said than done. Now, when you think of how these judicial calls are to be taken, there's one more dimension. When someone has before him various answers, various options as an answer available, what does he do? Does he wear the hat of a tax mercenary who is busy generating a stateless income, which doesn't get taxed anywhere, and he's comfortable with this? Or does he wear the hat of a tax policymaker who does not want to leave any taxing opportunity missed? Or a tax moralist who wants businesses to take care of the social responsibilities more than anything else? Or finally, does he wear the hat of a tax academician who can understand the inherent scheme and rationale of a tax provision on the first principles and apply the same in that perspective? I think what we have seen in the last few years, the way Honorable Justice Kapadia did it, and we saw tax academicians coming out of the tax judges. That is perhaps the role where the tax, how the calls are to be taken comes up. Now, last point I would make is that as for the media and environment, which is what Mukesh has put on the slides, I think yes, things may matter, and these things may even subdue otherwise independent and fearless judicial officers. The atmosphere of mistrust and suspicion, the atmosphere that prevails in India today is certainly less than conducive, and irresponsible media coverage could also be one of them for fearless decision making. But then what do? You have to develop your strength. I mean, as a judicial officer, I would think it is necessary that they have to remain indifferent to these things, and they also have to maintain a respectful distance from the stakeholders. They have to be a little aloof, away from the press, away from, the kind of knowing the reactions to what they do, and follow those high judicial traditions for this. It goes a long way in ensuring that you have the strength and ability to withstand such pressures. And that's where you have somewhere like Honorable Justice Kapadia, who is like a role model, and he'll keep on inspiring generations to come, not only for his brilliant orders and those pragmatic approaches to the tax laws, but also for his highest standards of judicial conduct on the bench, off the bench, in accordance with the high traditions of judicial office. That's my take on this.
Thank you. Before I hand it over to Michael Lang as to how does GAR fit into this debate, Mr. Parasan, very quick comment. Mr. Pramod Kumar talked about the influence of media. Would you like to comment on the influence of political environment on this debate?
See, I personally feel neither the media nor I think politics should in any way influence courts' judgments. And I think judges should completely keep away from both politics and the media. And the topic for discussion is what is the attitude and the role of the courts in this debate. Are judges well placed, or should they even bring morality into reaching decisions? But as far as India is concerned, there have been, I think, varying degrees in the approach to morality. And it all depends upon the individual perception of judges. And we saw how one particular judge in McDowell actually took an extreme view, I would say. And of course, in Azadi, the court showed correctly a greater latitude. And in Vodafone, with a great amount of difficulty, the court reconciled both Azadi and McDowell. And till then, actually, there was a lot of confusion. In fact, they said that we can actually pierce through the transaction and go into the substance was the argument of the revenue in many cases. And after Azadi, they went slow. And now after Vodafone, the concept of only look at as opposed to look through has been evolved by the Supreme Court. And as far as general principles are concerned, judges are of course swayed away by moral considerations, but that can only happen where actually the conduct of the assessee is so shocking, where, as Arvind Datar pointed out, there is a clear-cut scheme to evade tax. There is a device. Unless and until that exists, in no other circumstances, I think the judicial mind should actually innovate or find out ways and means to actually find out something was wrong, and this is opposed to actually morality or ethics, when it is otherwise actually legally permissible.
Thank you, sir. Michael, would you like to introduce the topic on how is the GAR fitting in this debate of tax morality?
Thank you very much, Mr. Chairman. Maybe before we come to the topic of GAR, a short general remark on the topic, and maybe taking a different approach since we've talked so much about taxes. If we talk about a completely different subject, and let's assume we are talking about speed limits, and let's assume that we have a speed limit of 90 miles per hour for the highway, and this is the law, and then there is a public debate whether the speed limit for environmental reasons or whatever should be reduced to 70 miles per hour. Then I think there are two situations where I do not have a problem, and there are two situations where I have a problem. One situation where I don't have a problem is if the driver himself thinks, well, this is not good for the environment, therefore I don't make use of the speed limit of 90 miles per hour, I drive slowly, and I drive maximum 70 miles per hour. If this is his or her personal decision, I think because this is in line with his consciousness, I think this is fine. Second situation where I don't have a problem is if the legislature, there had been an informed public debate, and at the end of this debate the legislature had decided, because these environmental reasons, arguments are so convincing, let's reduce the speed limit to 70 miles per hour, after the parliament had decided on that. I think this is fine as well. The only problem I see, or the two problems I see, is if we have a speed limit of 90 miles per hour, and then the police is coming and stopping you when you're driving 70 miles per hour and telling you, well, that's not good for the environment, therefore I'm going to stop you now, and therefore you have to pay a fine. I think with such a situation I have a problem.